All right, everybody, thanks for showing up today. This is the Military Investor Network monthly community call. We have a really cool opportunity here to learn from some ninjas, Scott Nelson and Murray Bowl-yer. Murray, I know really well. He's a good friend of mine. I've done some business with him in the past, and we've just always stayed connected. Just a great human, and his partner Scott. I've recently met, but have learned a bunch about him. So I'm going to introduce Murray. And then Murray, I'm gonna let you take over, and then you can say what you want about Scott. Scott, and you can,
I'll keep it clean.
yeah, keep it clean today. Keep it clean. All right. So Murray Bowl-yer, weird last name. I'm just gonna say it, Murray. I have a problem like pronouncing it every time, but you spelled it out for me this time, so thank you. So he's an Army veteran, so don't hold that against him. He This year, as you can see on his little screen, he was New Hampshire's Vetrepreneur of the Year. Pretty cool. He was a former Fortune 500 controller, and he has a passion for simplifying estate planning. He's been in a bunch of different fields, corporate finance career, but he saw how confusing and costly legal protection is. So that insight led him to Family Legacy Docs, which is a platform offering attorney drafted wills, trusts, and directives through guided, jargon-free software. He's a pretty funny guy. He's pretty clear on what he is helping you with. He's down to earth, super approachable, just a great guy to know and talk to. And he's going to tell us about Scott, who is his partner with Family Legacy Docs. So,
Thanks,
Murray,
Stu.
over to you, my friend.
Appreciate Stu. Anybody out there working with Stu, you're in good hands. The guy's great, and he's not paying me any money to say this, but really, not only business savvy, but he is just a genuinely great human being. Um,
Appreciate it.
and it's really, I'm really grateful to be in his ecosystem. So, real quick, my personal story I think is going to resonate. I don't take too long because Scott is the main speaker. So about 20 years ago, when our kids were real little, I first learned about trusts, and we decided to get one set up, and we went through the process, and it was expensive, a lot more expensive. It was pretty expensive, but um, we left that whole process thinking that's the smartest thing we've ever done. And some of the things we liked about it was you could map out exactly what was going to happen. And with multiple scenarios and multiple backup people in case something happened, and all the support documents you needed for health or for whatever. And another subtle thing, which was cool, was you could, if something happened to us, then our kids were like 8 and 9, and we didn't want to allow them to get everything when they were age 18. So you could kind of time phase when they get the benefits of all this. So it was really cool. We felt really good about ourselves that we had all this mapped out. But then, and we paid a lot of money, but then the next year, the law changed. So they had to rewrite a piece of it. It cost another grand. And then something else changed. And then something else changed. So it was a grand for each one of these little changes, which took them about 5 minutes. And then we figured out that they didn't actually fund the trust, which Scott's going to go into detail. And a lot of attorneys, they charge extra for that, which means, what does that mean? That means you got to put the stuff, the trust document is the infrastructure, but you also have to take the step of putting the stuff you want protected in the trust. It doesn't happen automatically. And if they don't do that, I mean, it's like taking a shower with a raincoat on. It's like you're missing the point. But a lot of attorneys charge extra for that, and they don't bring that up when they're discussing the price. So I was really excited about this solution that we're going to talk about today, and I'm really excited because Scott is my, I'm really excited to be partnered with him because he does he's the brains. He's a state attorney. He's spent a majority of his career in estate planning, helping individuals, families. I'm reading this, uh, and business owners understand their choices. He's the owner of the Excalibur Agency. He prides himself on being able to first educate his clients on estate process and then weigh their options after consulting with them regarding their unique circumstances. He's excited about doing this, which excites me too. He earned his LLM, which is a Master's of Law in Taxation from Boston University School of Law, his JD from Drake Law School, and his BBA from Southern Methodist University. He covered a lot of ground there. He received his CFP, so he's a certified financial planner as well, in the year 2000. So without further ado, I hope you enjoyed this presentation. Here's Scott Nelson. But before I hand it over the mic, I just want to say that uh, we will be monitoring the chat, and we're going to try to take questions at the end. If, so if you want to put some questions in the chat, we want to keep his momentum going, unless I see a question, which I think maybe we should interrupt Scott. But anyway, take it away, Scott.
Great. Well, thank you for that great, introduction. And I just want everyone to know, I learned this about 5 minutes ago. There's going to be a lot of Air Force guys on here
Navy.
and Navy. Okay. So no pilots.
Navy pilots.
Lots of
Okay.
pilots, just Navy pilots instead.
So my father got out of ROTC, was in the Naval Air Force, if there is such a thing, but they took him out of that. He had his first pick of, locations he could go to, and they said, "You're going to SAC." So my godfather and him were in SAC for years, and I'm here today because my godfather figured out how to crash land on an iceberg in Thule, Greenland, and they're able to extract everyone off the plane. And then my dad was able to go down to Forbes Air Force Base and see my birth. So I am lucky that not only could these guys fly, but they could pretty much land on anything. So, so I'm excited to show you what we have today. And I saw where the title was, at least the platform was the Military Investors Group. So I thought we'd do a couple things today. One is some of you guys are investors, but I'm going to tailor this a little bit toward limiting your liability if you have any rental properties, just as a start. And then I'm going to talk about the advantages of having a really comprehensive estate planning document package. And if you could hold your questions off till the end, that way we can kind of get through this because it's a lot of material. And I hope everyone learned something today. So I am going to share my screen. And can everyone see this?
Yes.
Yes, sir.
Okay. So we're going to talk about a little bit of reducing your liability while you're alive and best structure. Why would somebody want to set up an LLC? Then we're going to talk about how to make it better. And then we'll get into the estate planning discussion, why somebody would want to establish a revocable living trust and then flip it. And I'll get into what the flip it means a little bit later. But limited liability companies, why would you want to do that? Well, you want to limit your liability. If somebody has a slip and fall in one of your properties, you don't want them coming after all of your assets. So today, this is kind of what your estate would look like. This is what's available to creditors or people filing lawsuit against you. So what you want to do is you want to limit your exposure to just the asset. So if you have a rental property, a lot of people just buy that outright. It's in their name. And when they slip and fall, or there's a fire or something, then they're going to want to come after your estate because the money covered by insurance usually goes to the secured creditor first, which is your lender. So what's left after, the insurance money? Well, it's the real estate itself. So you kind of want to protect that. So LLC gives you limited liability for anything inside that company. So as long as you do everything correctly, then you want to be able to keep that protection for you and your family. So it doesn't cost much. And the LLC costs about $500 just in general. You can do it online. I think it's best to have an attorney because we'll get to it in a minute. You really want a proper operating agreement. So you start your passive income business, it works out great. So then you get another property and then another property and then another property. And my trick is just to keep them straight because I'm not very creative and doing LLC names when you register in the state. I just put the address. it's more likely than not, no one's going to have that address for the name of their LLC in the state your property's in. So things are going along swimmingly, but there's that guy who lives in 2120 Island Green, starting to get a little bit late on the payments. Trash isn't being taken out regularly. Something's going on. You don't know
Out.
what.
Get
And
out.
and then all of a sudden, he has a slip and fall, right? Most of the times, those aren't real, but they're going after a deep pocket. Things aren't going well. And so, what happens? Well, you got these LLCs here, and they're going to look at filing a lawsuit. So, what they do is, all right, let's look at the LLC registration. Who owns this property? Well, when you set up the LLC in your state, you're going to put your name and your address, and you're going to tell everyone that you're a member of that LLC. And then once they see that, they're going to file a lawsuit. And then in discovery, they're going to look for whether you have an operating agreement or not. And why is that important? Well, they want to pierce this veil. We call it the corporate veil of limited liability. They don't like that. They want to be able to get all four properties. They want to be able to get your brokerage account. They want to get your personal residence. So they're looking for the deep pocket. So when you have an operating agreement that's drafted well, what I mean is there's 9 major must-haves in that operating agreement. I'm not going to go in those today because that's a good hour of conversation. And there's some excellent videos on YouTube about what are the major halves as far as an LLC operating agreement. But if you just operate this as a professional, don't commingle your assets, use one property as a bank for the other, do all those just normal things that you would, normally do and not be lazy, then they're not going to be able to pierce that corporate veil. But the problem is, do we really want anyone to know my name or my wife's name? Do I want the wife of this guy coming up and harassing my wife in the front yard? This is going to be a constant pressure campaign in order for you to cave in. So there's a solution to that. One of the big things today is privacy. And here's your name and address all over these documents that you created. They have this nice passive income. So how do you solve that problem? Well, what you do is you create a Wyoming holding LLC. And that sounds complicated, but you can do it online. It doesn't even cost as much as most LLCs. And then what you do is you have the ownership transferred into the Wyoming LLC. So this Wyoming LLC owns 100% of the membership interest in each of your property LLCs. And why do you do that? Well, everything, when you set up the LLC in Wyoming, they don't even ask for personal information. So, it's not available. So when they go to look at what you have and who owns it, well, first of all, they're not going to discover the other properties. And when they look for their property that they're renting from, they're not going to see your name. So that's a really great thing for privacy. And that is really wonderful, especially when it comes time for litigation. Because what happens is Wyoming doesn't allow lawsuits from other jurisdiction to take your property. So all that can happen is you get a charging order against that property. When here it would be a charging order against the Wyoming Holding LLC. And what does that mean? Well, it's just an order saying, if there's a judgment against you, then that's all they can have. They can get any distributions you'd normally make to yourself. But if you've got kids, got friends, make them vendors and contractors to do work on the property, That's how you can scoop your money out and never be able to say, I'm taking a distribution to myself. So it's a worthless order and they can't force any distributions. So that's really nice. You can start off with a nominee agent and then the nominee agent changes it to, your name later on, but that's a nowhere exercise for the people looking for names because they're not disclosed anywhere. Then this really helps tax filings because if you have four separate properties, your accountant is going to do a tax return for each LLC. In a Wyoming LLC, you can combine all those and only have one tax filing. That really helpful when it comes around to tax time. And for lenders, if this started your first property and then you want to be able to get a loan to purchase second property, typically what happens is that income is on your Schedule E, which is where real estate income is located. And the lender, if he knows it's a rental property, he's going to be required to take a 25% deduction off your income because they're going to account for vacancies. But when you have your LLC taxed as a partnership, then it comes in your Schedule E, but instead of that being on page one of your 1040, it's on page two, and you get full credit for that income without any deductions for vacancies. So those are four really awesome reasons to why you would have an LLC, why you would have a Wyoming LLC. And I think that's really helpful for people who are looking for passive income and they have the awareness to be able to start a Wyoming holding LCC. But let's make it better for everybody. All right. So, why would we do estate planning with trusts? So this,
Scott, I'm going to interrupt you real quick
yeah,
before you get off Wyoming. Stuart, I know he said we'd hold questions to the end, but
okay.
this is timely here. He said, "Is Wyoming the only state that does this? What about Nevada and Delaware?
They both do it.
All
So
three? Okay,
yes, and you don't hear as much about Delaware as you used to, but Nevada is definitely one of them, and Wyoming. Those are the most popular ones, probably because of price, is my guess.
okay, thanks.
So, all right, let's talk about estate planning a little bit today. So, you have a lot of choices, and the market is full of people offering services. And how do you make sense of it? So we've kind of done a little study, excuse me, to say, all right, this is really what you have out in the marketplace. So I'm going to start basically from a cost perspective, what your options are, going from the most inexpensive options to the most expensive ones, and then show you a platform that you are never going to see from a law firm. So typically, we start with do it yourself plans because they're really affordable. But one of the big issues with those is that you have to do it yourself. And so you buy this program, you can get them at Staples, Office Depot, they're all over the place. And you buy the program, you go through a little interview. But what happens if you have a question? They have a little question box you can click on, but 9 times out of 10, that isn't going to answer your question. And you start feeling a little uncomfortable about making a decision that is going to be relative to a really important document. So they typically have an 800 number for you to call. And guess what happens? You call that number, they'll listen to your question, but invariably they'll say something like, well, it sounds like you need our more expensive program. So there's the little I got you, and it doesn't necessarily going to really help you in the long term because they only provide three basic documents. One is a simple will. And a simple will is kind of a bad term for a will because it just means there isn't a trust. And typically it says, if the husband dies before the wife, everything goes to her. If she dies before the husband, everything goes to him. And then if they're in an accident together and both die, or there's a second death somewhere down the road, then everything goes to the kids. So that's typically what a simple will has and means. They also give you typically a durable power of attorney, and that's a document that says if I'm on vacation up in Alaska, on a cruise looking at icebergs, and I need something signed in Colorado, well, whoever has my authority as my agent, which is this durable power of attorney, they can sign on behalf of me as if I was there in person. So that is a really nice thing to have. If you're knocked unconscious or you're in a coma for a couple of weeks, whoever has that authority can write the checks you would normally write for your business or what other affairs you have, and nothing has to stop until you get out of your coma. So that just really smooth transition of lifetime responsibilities. And then there's the healthcare power of attorney. And this is the agent that has the HIPAA authorization be able to obtain your medical information. And that's invaluable. If you have kids today and they're in college, they're probably age 18 or older. And the doctors aren't going to give the parents the medical information they're looking for if something happens without that authorization. So it's a nightmare for parents. And it's a nightmare for you. If you get in an accident and you're unconscious, if it's not life threatening, you're going to be sitting there on a gurney in the hallway until you wake up, because the surgeon isn't going to want to sew up your thumb without consent. And if you're unconscious, you can't give it. So your spouse or somebody else can give the consent if they have this power of attorney and say, yeah, sew up dad's thumb. And by the way, give him some medication, because when he wakes up, he's going to be pretty grumpy. So those are the three major documents. However, we have found that the sale of your personal information when you get these low cost plans is rampant. Now, I know we're all guilty of this a little bit, but when you get onto a website or get a program, they have a little user agreement, and you put that little agreement, I agree button, and you check it. Well, guess what it says on about page 36 of that agreement? Buried in the fine print is a little statement that says, you agreed to allow us to share all of your information with our affiliates and partners. And who's that? Well, turns out that's anybody who's going to pay for your information. So now you've just targeted your family to lifelong targeted marketing campaigns because you clicked that little box. So that's the lowest end of the spectrum. They're not very expensive. They do provide three documents, but for most people, it doesn't solve their biggest problem. On the other end of the spectrum, the most expensive plans are going to be from a full service law firm. They're going to have licensed attorneys. They're going to have first and second year associates that have just graduated law school. You have paralegals. And so they have a lot of overhead costs. But if I only had a choice between the two, I would always go with the full service law firm. One, they'll always be able to answer your question. And two, they won't sell your information. So, even though you're kind of biting the bullet a little bit, those were my choices. That's where I'd go. But they're not dumb, but they have a lot of overhead. So they're going to price their packages kind of in a bundle. And in order to do that, they really hope that they're going to recoup their costs further on down the road. So they have a hidden agenda, and this is never going to come up at your first meeting with a law firm because it hasn't happened yet, and they're under no obligation to disclose this to you. But this is definitely the conversation that the managing partner has with the first and second year associates about how the firm really makes money. So their hidden agenda is that they want to be the trustee or successor trustee under the trust document that they provide for you. And they want to be able to do the administration on an ongoing basis. Both of those they get hourly fees for. It's not cheap today. But the big one is probate administration. They want to take your family through this process, even though they have drafted a trust for you and you've signed it to avoid probate. And that is a huge unethical issue that I want to make everyone aware of.
Mm.
I don't like it. And you have an option. So, of course, they want to be your consultant for the rest of your life and do the annual meetings with the family. But you're going to find if you look for a trust based plan anywhere in the United States, they're going to come in somewhere between $4,000 and $8,500 on average. So your average is going to be somewhere around $6,500. But mind you, they don't really make a profit on that until later on these other areas. So they will always give you your first consultation for free. Because if you made the decision to dress up, drive to the attorney's office, and listen about their services and what they can provide for you and your family, they know they've got you. All right. So they're going to give that first consultation as their giveaway, but they expect another $2,000 to $3,000 of consultation fees while you're putting this on top of the fee they charge you for the documents. And that can be pretty expensive. We talked to a lady 2 weeks ago that spent $10,000 on her will and trust in New York because during that interview, the attorney, I'm sure, was judging what was their pain threshold for the fee they were going to charge. And they threw out a number, and the client said, okay, let's do it. I need to have this done. So that's going to be your highest cost. So here is an option that you have today that you're never going to hear from a law firm. And this platform is going to give you the same or better documents. And
Scott,
how?
can I interrupt you one more time?
Yes.
I think it has to be said that you came from that world. I mean, that's why you
Yeah.
know all this isn't just conjecture or rumor or reading, magazines. You know that the what you just described is where you came from, and
Yeah.
right. So it's this is not, and that's why you like what we're doing now. You can see the
Yeah.
anyway. I just wanted to say that in case it wasn't obvious.
So, I mean, it's thrilling. Software has changed our business for the better. Because back in the day, you used to put together your document in Microsoft Word, and you'd use the template, and you'd use other prior clients, documents, and you'd cut and paste, and you build your document for your client. And that would take hours and hours. And if I had it in a different state, I'd have to research the trustee powers in those states and made sure they were state compliant. Today, if I type in the state that my client lives in, that's automatically done. And when you used to cut and paste, you'd have to proofread it. And here's the problem with proofreading: you know what that paragraph is supposed to say, and you know who your clients are. So your brain says, this looks perfect, but you may not have changed the names in those documents. And I reviewed thousands of documents from other law firms. A lot of them had tons of clerical mistakes. And if you pick that up in your draft conversation with the attorney, they would always say, oh, good catch. That's why they call it a draft. And they would try to laugh it off and then, feel embarrassed and then go back and make those changes. But with software, those mistakes can't happen anymore. So the big law firms can afford that software. The small individual solo practitioners, they can't afford it. So they're still building these documents by hand. And so, this company has made the economic decision to have and provide a lower price and get more clients and more market shares, and they're doing a fantastic job of that. So I'm going to explain that you're going to get the same document that's going to be valid in every single state. What's different is these do-it-yourself plans, they're great, but they don't have anyone to help you. They don't have an attorney to walk you through your options. What are the ramifications for making some of those decisions? You're going to get that with a law firm, and you're going to get it with us today because I'm the attorney here to help you through those. And I'm going to make sure that you feel comfortable with every single decision. So it's a lot of fun and you have a lot of options. But I'm going to show you why this is probably a better overall long-term value and give you a introduction and education on wills and trusts. So why a revocable trust? Well, a revocable trust is a document. Number one, it's got three major benefits. It avoids probate. And I'll explain what probate is in a couple minutes, but it's not fun. It's expensive. So avoiding that process is going to save your family thousands, tens of thousands of dollars. Let's go back to our example with the four LLCs. Let's say, for education purposes, that all those properties together are worth about $1.5 million. A lot of that's happened in the last 5 years, 6 years, So that's really appreciated in value. Well, probate takes a fee based on the fair market value of your properties. So nationwide, that's about 10%. So there's $150,000 that's going to go toward probate, and you don't have to pay that cost. So that's an avoidable expense. A revocable living trust is very private. Nobody knows what you have. Nobody knows who it's going to go to. No one knows who your beneficiaries are and when they're going to get it and how much they get. So when I look at setting this up, this is the vehicle I'd put my Wyoming LLC in. I mean, no one knows who owns those LLCs now, and no one's going to know who's in this trust. So it's just an added layer of privacy. And the document is very flexible. I grew up in Kansas. All right. So when I heard somebody had a trust, I thought, wow, they really must be rich, or, that's really complicated. Well, it's just a piece of paper, but you can change it every single day. And because people typically had money, they had advisors that showed them you could save some money for your family. And that's all it is a matter of awareness. And what I like about it is that there's no restrictions in a trust from a day-to-day basis. You can change it whenever you want. That's why they call it revocable. And you can make a decision as what's going to be the best financial interest for each beneficiary. So what do I mean by that? Well, I have three boys. One son has saved just about every nickel he's ever earned. So he's a saver. I don't mind giving 1/3 of my estate when I'm gone to him outright, because I know he's doing a good job of managing that. Now, my oldest son is on the autism spectrum, and you would never know that. He's the smartest guy in our family. His, verbal manipulation is just phenomenal, but he's a little impulsive with his money. And just a little story, we were at a soccer match one time and he asked for a little ring pop, which is kind of like a lollipop on a ring you wear. And he asked to go get one. Of course, I'm going to buy a ring pop for him. And 20 minutes later, well, first of all, here's the other part of the story. I give him $20 because that's all I had in my wallet. So I said, bring me back to the change. So about 20 minutes later, a lady comes up and she's got a stroller and two small kids with her. And she's, I just want to thank you. Your son is so generous. He gave everyone at the food truck, a ring pop. He bought the whole box, and everyone's so happy. And that was just the nicest thing. Well, I can't go back and get all the ring pops the kids are sucking on, right? But he's a little impulsive that way. So I've structured our trust to have some oversight. So with the trustee, he has somebody to kind of have a check and balance on his spending. And so I'm treating both of those kids separately. And that's a really great thing to have a revocable trust and be able to do that. So here's your estate today, like we saw before. So at death, the first thing the trust or the court is going to look at in probate is, hey, was there a trust? If there's a trust, you're telling the probate court that you have privately contracted with yourself to handle this probate process. And they're going to reward you by not having you pay any fees or wait any particular amount of time. And anything that you have can go to your family, it can go to charity, it can go to your best friend and neighbors, whoever you want, and you're not going to go through this probate process. However, if you don't have a trust, then you're going to go through probate. So a lot of people are under the impression if they have a will, they're going to avoid probate. And that can't be further from the truth. So whether you have a will or whether you don't have a will, which is called being intestate, both of those processes and situations are going to go through what I call the funnel of probate. Because while you start off with a lot of money, there's going to be a pretty big hit to the value of your estate before it gets down to your family, whatever is left. So this is what happens. You die, and then you have to get on the docket for the probate judge. And that can take a while. These people, they love golf, they love traveling. So, I mean, you think it's simple, but these guys really don't like their job. So they're out of the office as much as possible. And they're going to hire an administrator. So if you happen to have a will, the person that you would direct to help your family in that situation is called an executor. And he does the same job that the administrator does if you don't have a will. And they're going to take your family through this probate process. So you have to pay all sorts of fees. You hire an attorney or a law firm. They're going to post a bond. They're going to take an inventory of all of your assets. And then on things that are valuable, like property or collections or artwork, they're going to get appraisals on those. And then once that happens, there's going to be a publication on the internet in your local paper that you've died. And they're going to announce that, hey, if you're a creditor, now's the time to come forward, because, if you don't make a claim, you are not getting paid. So once that has happened and the payment of taxes has occurred, then there's a division of the assets. And guess what? If you don't have a will, it's going to be based on a formula. The nice thing about having a will is that is the time where you've told the court, this is where I want my property to go. But it's always been already through that probate process. If you do not have a will, it's going to be based on a formula. So the first thing the court is going to look at is who's alive. Is your spouse still alive? Do you have brothers and sisters that are alive? How about your parents? Are they still alive? And they're going to look at see if you have children. Are your children adults or are your children minors? If they're minors, they're going to appoint a guardian to raise that kid until age 18. And then they're going to take that guardian through a little financial interview. I mean, they might be a great person to raise the kids, but if they don't know anything, the difference between dividend producing, stocks and regular stocks, and what a fiduciary is, and how to offset that for maybe ordinary income, all those things, they might appoint a guardian for the property of that person. Well, why is that necessary? Well, guess what? The property typically is split between the spouse and the children, if your spouse is still alive. If not, then they're probably have property going to your parents if they're still alive, and or brothers and sisters. But typically in most jurisdictions, the first 10 to $100,000 of property goes to the surviving spouse. But that's usually the real estate, because the probate courts don't like real estate going to minor children because they can't maintain it. They can't pay the mortgage on it. They can't pay the insurance or the taxes. So that goes to the surviving spouse. Now, if that's more than half the estate, then she's in a position to have to borrow from the kids, because typically what happens is this estate is split 50-50 between the surviving spouse and the kids. And then when they turn 18, guess what happens? They get their money outright. So I don't know what your money management experience was like at age 18, but I probably would have bought a new car. And that may not have been the best financial decision I could have made. And of course, that's going to be a priority for a lot of kids. And do you think there's any conflict could possibly be looming at that point in time for your surviving spouse? So that's what happens. And then there's another thing that comes up from time to time. So imagine what happens when they have that publication. And imagine there's Billy Bob, who lives in a van down by the river. And maybe he was a motivational speaker at one time in his life. And he sees that you've died. And he goes, you know what? I think John owes me some money. So John probably never heard of Billy Bob. But what Billy Bob does is he goes to the probate judge and makes a claim for $8,000 against the estate. Because believe it or not, if you have a will or don't have a will, within a couple mouse clicks, they can find out everything that he owned. And he says, this is worthwhile for me to go after. Just like if someone sees who is the owner of all those LLCs, they can see that, yeah, there's a deep pocket. I can see this guy lives in a nice neighborhood. There's a deep pocket. So he makes a claim against the estate. The attorney comes to your surviving spouse and says, do you know a Billy Bob? I go, never heard of him. As well, he's made a claim against the state for $8,000. It's going to cost $12,000 to litigate this. What do you want to do? Well, that puts the surviving spouse in a horrible position. Do I want to spend $12,000 to prove an $8,000 fee isn't valid? So a good attorney is going to go to Billy Bob, maybe offer $1,000 and see if he goes away. A bad attorney who's on the list of approved attorneys to take families through this probate process because they can't get clients otherwise, they're going to want to litigate it because they make $12,000. So is that going to happen in your case? More often than not, it is not going to happen, but it has happened. And, we know who these guys are, and they change names and faces because they're out there to get free money. So that's not the only problem. They take a percentage of your gross estate without any offset for the fact that you might have mortgages on your property. And that doesn't seem very fair. So just look at a $500,000 home. They're going to the fee for probate is going to be $40,000 on that home because there's all these other costs. Nationwide, it's going to be 10% of the value of all your assets. And guess where that money goes? It's going to be for the attorneys and administrators who helped you draft your trust, but didn't do the most important thing for your benefit. And why didn't they do that? Because they get this money at the end of the day instead of you being able to keep it for your family. So I think you can agree that's not very fair, and it's a pretty grim process financially And it takes somewhere between 18 months and 24 months to go through. And the whole time, everything is locked up by the court because nobody's going to want to pay anybody anything because they have personal liability until you've cleared this probate process. So that's ugly. And how do you avoid it? Well, you avoid it, like I said before, by having a trust. But you have to do one very important thing, and that is you have to fund your trust. And that's a term of art. All it means is you have to change the name of your accounts. And when you do that, that's called funding your trust. So let's say you have a checking and savings account, a Bank of America. And today it's in your name and your wife's name, or vice versa. Well, when you rename that account, you're going to name it now to the Doe Family Trust, John and Jane Doe grantors under the date they did that. That's the only change you're going to see. There's not going to be any restrictions. You can make deposits, making distributions. But once you've changed that name, now that trust is what we call funded with that asset. And you do that for your brokerage account. You do that for your business LLCs like the Wyoming LLC. You do that for your personal assets. The only thing you don't do is transfer your retirement assets into that trust because that would make it immediately income taxable and you would not be a happy camper if that happened. So we make sure that doesn't happen. The third party administrators for your retirement accounts are going to warn you you don't want to do that. But I mention it here because people have done it. And what we do is just we want to make the trust the beneficiary of those accounts. So you just transfer and change the beneficiary designation to your trust, and then you've avoided that problem. The only thing that costs money is changing the deed on the real estate. You have three ways to do it. The best way to do it is if it's yourself, because you go down the county where the property is located. The clerk's going to help you. You know, you pay a fee of about 20, maybe $10 for a quick claim deed, and then pay a fee to change the deed somewhere between $50 and $60. You've done that, then you're golden. That's what funding the trust is. You should Google why attorneys don't help you do this. Their answers are, well, that's a financial transaction. We're really legal, but that's not the answer. The answer is they want to take your family through probate, and they could easily get a disclaimer signed by the family and help them through this process, but they will lose out on 10% of the value of your estate. They don't want to do that. So, what happens now that you have this trust? Well, anything and everything can go to your family outright. It's without probate. It's very fast, maybe 10 to 14 days. That's a lot faster than 6 months to 2 years, right? And it's completely private. Nobody knows where your money's going to or who it's going to or how much they get. And think about this. Now that your children have these assets typically, well, how do you protect that for them? Because now that they have taken receipt of this property, it's subject to claims of creditors, claims for automobile accidents. What about divorce? Well, you can structure this trust to say, yeah, kids, you can have this inheritance that I've given you, but you might want to consider keeping it in the trust. Because if you keep it in the trust, you can treat it like a faucet. Whenever you need money, you can turn the faucet on. If you're under some sort of liability or going through a divorce, you can turn the faucet off. And that's because you're a beneficiary. You're not the owner of those assets. So no one can get those. So it gives your kids and your family another layer of protection that they didn't have before. So that is a huge benefit for anyone and why you'd want a revocable living trust. So I think that's a really great thing. And so when you look at multi generational protection, that's available. So when you look at a comprehensive estate plan, you're going to look at six major documents. You're going to have the revocable living trust, and you have a lot of options. I just want you to know that you can individually customize this document to take care of your kids. And like my oldest son, we have a special needs trust. So if he's ever out there on his own and at some point the state takes over his care, which I don't think will be the case in my situation, but there are a lot of special needs kids that are in that situation. Whatever money you've set aside for the kids, the state won't be able to get to it. It's there to provide things over and above what the state would provide. Just know we can take care of your family no matter what. We also provide a certificate of trust. And when you go to change the name of your trust, the banker's going to see the trust. When you change the name on your investment account, the broker is going to want to see the trust. Well, you spend all this time and money keeping it private. Do you really want your banker and broker to know everything? So, this certificate of trust document is the document that protects you from that disclosure. So, you give them the certificate of trust and you're golden. You don't have to give them what they're looking for. We also provide a last will and testament, but this one's different. It's called a pour over will versus a simple will. And the pour over will only has one beneficiary, and that's your trust. And so it's really sophisticated in that it totally synchronizes with your revocable trust. And it says, whatever I own, to the extent that I didn't get around to titling it in the name of my trust, I want it to pour into the trust because the trust is the document I'm using to distribute my assets. So it's great. And it saves a lot of liability for you and for your attorney. It give you the same financial power of attorney with the proper HIPAA language, the healthcare power of attorney. And believe it or not, a lot of law firms want to charge extra for the living will, but that's the document that says if you're brain dead, I mean, basically you're in a vegetative state and you're hooked up to tubes feeding you and you're hooked up to a machine to help you breathe. Do you really want to be an experiment to see how long they can keep you alive? You can let your family know, hey, at that point, it's okay to pull the plug and save some money. I'm ready to see what the next chapter is all about. And you're just letting the family know it's okay. They don't have to do it, but you're allowing them to say, hey, I want to donate some organs, let me, go. I love you guys. So Family Legacy Docs provides all those six major documents and whatever you need. And compare that to a full service law firm, that charges about $6,500 on average. They have a lot of additional things that you should consider. They have an online document vault where after you sign those documents, you upload it. And so now you have access to it 24/7. You can make, a search right away. And because if you have a conversation with the son or daughter 10 years down the road and they say, I think we're getting a divorce, you can look on your documents, see what it says, even if you're on vacation. But they've spent a lot of time making sure to help you to be able to fund your trust. Now they charge $29.95 a year to keep that document vault. It's all like cloud storage. And as an attorney, I pay $160 a year for Dropbox. So when I look at and say I can put whatever I want in this document vault, that's a bargain. So I'm on these webinars every month for estate planning attorneys just to kind of keep up to date with what's changing in the marketplace. And when I tell them that we provide all six major documents, plus we give them unlimited updates, changes, and restatements for the rest of their life without any charge, they just groan. There's no way they can compete. Nobody in the world has this feature and this benefit. And when I tell them that we provide this for $3,000, for a married company, they know the market has changed dramatically and they're going to have to change what they're doing right away. So, this is what Family Legacy Docs charges, but because we're been exposed to a network of people that we've never been exposed before, we have changed our website, and we will say for the next 10 days, you make a commitment to at least sit down with us sometime in the future and get on our calendar. We're going to reduce that down to $24.95 for a married couple. And if you're single, we're going to give you an even better deal, which is $1,995. So I think that's just amazing because when you look at what attorneys charge just for their consultations, you're going to spend more than $2,000 just on consultations taking you through this process. And every part and parcel of this process is going to be attorney assisted. So it's all inclusive, and we're going to give you personal funding assistance to make sure that happens and that you actually fund your trust. And we're never going to charge you any fee for consultations. How frustrating is it to call your attorney up, ask them a question? They're going to call you and tell you, all right, I'll research that. I'll get back to you. They'll call you the next day or day after, and they'll answer your question. But guess what you get in the mail 3 weeks later? You're going to get an invoice for an hour of time. And I guarantee you, it didn't take an hour to research that question. So I think, for the value, I think that's why I say it's going to be your best overall value for the long term. And here's the hierarchy. Remember when I said flip it? Well, I think you should start out with your estate plan and include the revocable trust. That gives you a layer of privacy, and it basically prevents your family from ever having to experience that probate process. And then you put your Wyoming LLC in your living trust because your state individual LLCs are in the Wyoming LLC. And if you have the proper operating agreement, it will never be able to pierce that corporate veil. And once you get those documents all in order, that's when you buy your property. So I think that is just a great hierarchy of the order of things, to do. And I have a little tool down here that I use with people that do buy properties. And I will just say there is a tool out there that exists. And we had one client has 23 properties. And this tool was able to guarantee that they save $11 million in interest. And it uses a program called the Money Max account. They'll guarantee the amount of money you save, and they'll guarantee the day, the month, and year you'll be out of debt. And it's usually a third to a half of the time that you normally would have been in debt with the mortgages. So there's a lot of things that are available out there to everyone. And I think that today, a lot of you are sitting in the position of being a gatekeeper. You know, there's no way you can remember all of this, but you can tell your significant other, hey, we came across a great platform, and I think we should go investigate this. And if you want a free consultation with your significant other or book an appointment with Murray and I, take a picture of this QR code. It goes right to our calendars, and we can set you up with a free consultation. It's getting us out there in the marketplace. We're having a lot of fun. This is my contact information. This is Murray's. And now I'm going to open it up to questions.
Thanks, Scott. I want to thank Stu for putting this together. Actually, that was a deal that we want to honor Stu because he's a good friend of mine. He is familiar with the Money Max account because we've talked about that before. But that's not the point of this call. But Scott's just sharing some other tools that are available for the right person. So we have some great questions, Scott. So I mean, we'll stay as long as you guys have questions. But We talked about Wyoming is the only state. No, Nevada and Delaware also, and we think the only difference is the price. I think the functionality of what happens is similar to what Scott talked about for Wyoming. All right, here's a good one. I was told you don't need a trust until you have a net worth of over 5 million because the main reason to do a trust is to save on probate and asset transfer tax due to the cost associated with setting up the trust. What do you say to that? 5
Okay,
million. 5 million is what is the question.
a trust is appropriate for most estates that have over $40,000 of assets. If you have $40,000 or less, you can go what's called a simple uh, estate probate. And so that means your probate's only about 6 months long instead of a year and a half to 2 years. Still, everything locked up. If you have just $40,000 to your name and everything's locked up for 6 months, who's going to pay for your funeral and those expenses? Who's going to pay to maintain the property? Pay the mortgage, all of that. So it's still a hassle. $5 million used to be the number for estate tax purposes. And so we would create irrevocable trust in order to transfer assets out of the estate because anything over $5 million would be estate taxable, which is like a 55% estate tax associated with that. Today, it's just under $14 million for a couple. And they were going to reduce that. But now, if you have an estate that's just under $28 million today, then you can do everything without gift taxes. And, unfortunately, I'm not there yet, but hopefully, maybe some of you are. We can talk about that. It's something I've dealt with a lot in the past, but 99.99% of people don't have to worry about it. But you're going to go through probate and you're going to have those fees associated with probate and everything locked up if you have an estate that's basically over $40,000.
And don't forget the other benefits of it. Like I blew through it very quickly when I was speaking, but the ability to designate different people to handle all these situations and like third. I know when we set up ours, we have first and second and third, if this guy's not available, then choose this sister-in-law and then this and then the timing of when everybody gets it is just so much. Believe me, I don't have 5 million in assets. It was still worth it at a decent price. But good question. So, and I think you talked about this, but you can kind of retouch it. So even a will has to go through probate. Is that
Yes.
a will is like a wish list, right?
Yeah. You're letting the court know who you want to be the quarterback for your family, the executor, to take you through the probate process. And you're letting the court know who you'd like your property to go to. Because a lot of people, if they don't have a will, they're stunned to find out that not everything goes to the surviving spouse. And the court says, you may not have wanted everything to go to, them. And of course, you probably want some property to go to your kids. So we're going to make that decision for you, or perhaps your parents or your brothers and sisters. And, if your brother's a guy who destroyed your Michael Jordan tennis shoes, that may not be the guy you want any of your property to go to.
Very good point. All right. So I think I know the answer to this one, but I'm going to let you say, does life insurance go through probate?
It does not. It goes via beneficiary designation. And that's why I don't include life insurance proceeds on your whole estate. And so that's one of the nice things and benefits about life insurance. However, because it goes to the beneficiaries outright, we often take the beneficiary designation and put it into the trust because then we can control how that's distributed. And that's a really good idea. That's the document we're using to distribute all of our assets. So why not use it for the insurance proceeds? It's going to get to the family in the pretty much exact same time it normally would have gotten to them. But now you have a trustee in charge and you don't
Get more
have,
control.
yeah, and you don't have, it's not open to liabilities that they normally would have once they take receipt of that property.
Good. So, by the way, whoever asked that, I didn't write down who asked that, but if that doesn't answer your question, let me know. Good, good. I like that answer. So here's a good question for investors. If you have real estate properties in an LLC, do you have to put the deeds individually into the trust, or do you just put the LLC in the trust?
You actually transfer your membership interest and you sign it into the trust because it isn't like a stock. It's an LLC is their members. So you transfer 100% of your membership interest into your revocable trust. And your operating agreement, and I really, it costs $500 to go through an attorney, go through all the things. Don't get one on the internet. It might have been for multiple family properties or for partnerships, and it's buried in there. And they're going to blow up that operating agreement they can. So go through just an extra little expense to make it tailored for you and say, be able to transfer it if you already own one into your revocable living trust. Better yet, purchase the property in the name of your, you know, revocable living trust in that LLC. So that's the best way
Great.
to do it.
If
Mr.
anybody,
Scott, a follow-up question to that. I asked that question. So you initially said to structure our LLCs by putting your recommendation was each individual property into an LLC and then putting all of those LLCs into one Wyoming LLC. So
Correct.
then would you just put the membership interest for the Wyoming LLC into the trust? So you only
Yes.
do it once?
Yes.
Okay,
That's why I said flip it. Take everything in order that we just gone through
got
and
it.
then
Okay.
turn it upside down. And that's really the order. Get your estate documents done first. That's your immediate liability. Everything else is just really nice liability to avoid. And you can do it if you do it properly.
did that take care of you there, Trey? You're muted. I'm going to assume that's okay. All right. Good question, Trey. Got more questions pouring in. All right. Does changing, I know the answer to this, but Scott, does changing the title of your property to your trust impact the loan in any way? Will the
It does
lender
not.
call the due on sale clause?
So there was a law enacted, I think it's called the St. Germain's Act or something like that. It prohibits all lenders from enforcing or putting in place or triggering the due on sale clause for putting into a revocable living trust. So you're
And,
not
and
going
what
to counter that anymore.
what's the name of that title? Uh, what's the
Quick
name of that?
claim deed.
There we go. There we go. Quick claim deed is what it's called. Yeah.
Yeah, a
Yeah.
quick claim deed is really interesting. It's one page and it says, hey, whatever I own, and it can be nothing, but whatever it is, I'm transferring it into my trust. So here's the danger. When you buy a piece of property from somebody, get a warranty deed because they're saying, I own this property. If they try to pull one over on you and give you a quick claim deed, they may own nothing and you're buying nothing. And they're giving us a, hey, I sold him whatever I had. It turns out I didn't have anything, but he bought it anyway. So, but that's the easiest document because you're basically selling it to yourself. You're saying, whatever I own, of course I own it. I'm going to transfer it into my trust. And the clerk at the county where your property is located, they've seen a million of these. Very common. They're going to sell you the quick claim deed for about $10. You put the legal description of your property on it. You put yourself as the grantor and your trust as the grantee, and you're golden.
Every state's different, though. New Hampshire's
Yeah,
where I live. It was not as smooth, but for most states, it's pretty smooth. Pretty smooth.
yeah. This isn't legal advice because I don't know where you live or your particular situation, all that stuff. So,
In
and we're
theory,
not, yeah,
yeah.
creating attorney-client relationship in this meeting today. So, I guess I should have said that at the beginning.
All right. Thank you for bringing that up. All right. So this is a question from Stu, I think. What if you are a 50-50 partner in a business, regardless of the structure? What if you're a 50-50 partner? How do you do that within the trust when your partners aren't family and you don't want to be a beneficiary?
Well, what does your partnership agreement say? If they allow you to transfer your interest to a third party or anywhere else without their approval, you're okay. If you want to transfer your partnership interest, then, and it doesn't say that, you have to make an amendment to the partnership agreement. It's likely once they see the advantages for doing this, they're going to want to do it themselves. So you have to educate them a little bit. There's no reason why they wouldn't want to do it. You are the trustee of your trust. So you're the same person. That hasn't changed and will not change for the rest of your life. You have full control over it, just like you did your entire adult life.
That makes sense, Stu? All right. So here's a question from Michael. Okay, this is a long one, so hang in there. My
Okay.
father is in his mid 70s. For Medicaid purposes, if he should become ill and require a nursing home, how does elder care attorney fit into this construct? And then he's got some more comments here. Why don't you take that? Well, let me just read the rest of this. I had to put my grandmother in a nursing home and essentially had to turn her estate over to Medicaid. I've been told an irrevocable trust can help prevent this. So bottom line, do you provide a similar service as elder care attorney for someone in my father's case? It's a long question, but
It is. So, 10 years ago, they enacted this law that says attorneys help clients avoid, and the clawback of the assets, they're personally liable. Well, the Bar Association got involved and stopped that. But this platform does not handle or create irrevocable trusts. And Medicare says if you put it, you're going to go into a facility. We're going to allow you to come in the facility and you're going to spend down your assets. And then when those are gone, if the only asset you have is your home, we're going to take care of you. But at the end of this process, we're going to have the ability to sell your house and get paid back for providing that care for you. And that used to say, if you did that 2 years in advance and made the 2 year mark, you're golden. Well, people are living longer. Medical science is better. And now they've extended that to 5 years. So you have to live for 5 years, even though you've transferred your property to an irrevocable trust or transfer it to your children. They can look back and change that as if it never happened for a 5 year period. And guess what happens with Medicare today? You think the government is looking at extending that clawback period? Well, they certainly are. So you can transfer the house to an irrevocable trust. We do not provide that. There's a lot of liability. It's very expensive. And that's just not available on this platform.
so Michael, does that answer your question, or do you need any clarification on that? Is Michael still on the call? All
Yeah,
right.
he's on.
All right, Michael, if you want to say
He
something, you're
says
muted,
he
but
says that's good.
otherwise, okay, he's good. All right. So yeah, irrevocable trust is a completely different animal, which has different circumstances where you'd need it. It's not, for the right situation, it's the right tool, but that's not what we have here.
Hey, can I want to
Yeah,
follow up on that. So
yeah.
if I put all my assets into my irrevocable trust today, 20 years from now, I have to go into a home and I'm on Medicaid. If that's the case, Medicaid cannot take and sell back my assets because they're already set in an irrevocable trust that happened 20 years ago. True statement?
Yeah, that's correct.
So the earlier the better is what you're saying.
Yes.
Yep. For that situation, yes. Okay, Sean, good question here. Can you speak to the interplay between being a beneficiary of a trust, i.e., my parents leave their estate to me, as well as setting up my own trust, establishing a trust for my kids? How does the trust structure work across multiple generations? Should you combine these somehow or keep them separate? What are your
Well,
thoughts on that, Scott?
they are separate by operation of law. And so the good news is you're a beneficiary of your parents. I've never met anyone that was disappointed in being a beneficiary. And your kids will feel the same way as far as being beneficiaries under your documents, but they really aren't commingled until your parents die. Then that trust terminates and distributions are made. Maybe you have the option for keeping assets in that same trust that your parents had, just for additional layer of protection. But if you take receipt of it, then now it's in your estate and you have to make plans on how that's going to be managed for your kids. And that's why that will go and fund your trust. So it can just keep on going down the line. You're going to have grandkids someday, and you're going to hope your kids put together a nice trust-based estate plan for your grandchildren.
Sean, does that answer your question?
Yep, yep. I think that makes sense. Appreciate it.
Okay, good question. All right. Steven asks, is the same with your investment accounts if you have beneficiary listed? Is that the same? I think we answered that, but
Well,
on the
some accounts have payable on death or transfer on death. That also avoids probate. However, it comes to them directly. And you may not want to have assets go to them directly because if they get divorced, that becomes part of the marital estate. Or if it stays in trust, that soon to be ex-spouse doesn't get any of that money. So those are just some considerations that happen in a detailed, interview process about, what is your family situation? It can be really easy, or you could have a really dysfunctional family. And we have heard everything. And so we can address different ways to do it. You are our client. So we're going to listen to you and design this relative to what you would like to have happen and make sure everything's okay.
Okay, good question. That was Steven. If you have any follow-up, Steven, let me know. All right. And Trey, okay, here we go. Trey asks about the liability concerns of a renter suing you. How does an umbrella insurance policy compare to an LLC? I've had my insurance agent recommend an insurance policy. I've had real estate investors recommend an LLC, and I've had financial planners recommend both.
Yeah.
Do I need both?
Yes. Okay. So what's the insurance for? All right. It protects against accidents. And, things where, you had a duty to care to warn. A lot of accidents are constructed, they're on purpose in order to scam you. The insurance company can decide whether or not they want to, litigate that on your behalf. So they have the tools and resources. That's what you buy with your, premium dollars. So if, the give and take is the negotiation happens with the attorneys and they make it painful for the litigant and they're going to try to negotiate something. That's all what the insurance does. It provides that pool against that liability. It also protects you from having to sell that income producing asset. Because if you had to sell that under duress, you're never going to get the true value of that asset. So the LLC protects you as far as being able to attack all of your other assets that you own. But the insurance helps you negotiate the give and take that's going to be going back and forth with the litigant. And that's where you have real leverage, because if you can only have a charging order, you can say, okay, you can wait, or, I'll give you $5,000 for the twisted ankle, your twisted knee. And they're going to sit there and go, well, God, I may never get the money, or I could have $5,000 today. And that's where the real leverage comes in as far as having these LLCs, and especially having the Wyoming LLC, because the charging order is just a word. It doesn't mean they're guaranteed to get money, because you can take that money out other ways and they'll never see a dime of it.
Okay, so Trey, hopefully that answers it. And I think you answered the Stu's question. How does umbrella insurance come into asset protection? Is it worth it? I think you just said it's worth it.
Premiums are pennies on the dollars. Build that into your business model on your cash flow analysis, and then just say it that's a cost of doing business.
Okay, good. All right, that's the last question. So, any final thoughts? Any final questions? I want to thank everybody for hanging in there. We went way over. Thank you for your interest, Stu. Thanks again for setting this up.
Yeah, man. Good.
Be sure to save that image of that QR code if you want to book a call. Oh, put it back up. Well, it's
Okay.
behind me on my shoulder, but Scott, can you put up the code again?
Yes, I can. Just
And
And
this is
all
not a
the
sales call. It'll just be another educational call because you probably want to bring your significant other in. And that's the point of this. We're not going to try to sell you.
And Murray, what I'll do is I'm going to send out a replay
Okay.
to those on my email list. If you're not on my email list, please, if you want to be on my email list, I'm going to send out the replay afterwards. You can put your email in the chat and I'll add you to it. Otherwise, I'm going to send out this replay to my email list and I'll include the direct Calendly link to book a call with Scott and Murray.
Awesome. Very good. We hope we answered some of your questions. I learned something every time I hear Scott speak. You can tell he's getting into it. We really like to be able to provide this because it's affordable. When you think about the big picture, it's pretty affordable for what the benefits are. And I can tell you that it really gives you the peace of mind to know that you've got everything lined up. And then, ultimately things are going to change. I think I read somewhere, Scott, that the average trust has 7 changes.
My
You know,
dad, who was 91, made 4 changes his last year of life relative to his second wife.
Wow.
And, yeah, he paid a lot of money.
yeah. So that alone, you don't want to, it's just really comforting to know you have every angle covered. At least that was for me. Again, my wife and I thought it was the best thing we ever did. So hopefully this was helpful. Stu, thanks again.
Yeah, man. I'm going to share my screen just real quickly to kind
Yeah,
of
go ahead.
sign us off here. Scott, if you could
Oh yeah,
just
you got to take
stop
yours down.
sharing.
Yeah,
And this is just for the folks that aren't a part of the Military Investor Network. So this is the free monthly community call that I set up to have people within my network come and speak to share education. But this is the platform as members of the Military Investor Network. And I just wanted to show you this real fast.
cool.
We have a really cool discussion forum of lots of different topics, you know, single family, multifamily, commercial, personal finance, stocks and mutual funds, alternative investing, lots of conversations going on. And I started this about 3 weeks ago. We already have 37 members, and just a really great place to have conversations. The other really big thing is we have every single Tuesday a lunch and learn where members of this community are teaching different classes on what they're knowledgeable on. And then there's lots of other education. The community calls get put in here, but then the lunch and learns, you have to be a member to be a part of that. So we have real estate investors, we have attorneys, we have insurance agents, we have lenders, we have realtors, we have wealth management planners. We have lots of people that are in this network already. All people in my community that I know, and it's just going to continue to grow and get bigger. For what I think is a pretty cheap price to be a member of something like this, at $50 a month. You can learn a ton, network with a ton. I think network, they say the network is your net worth. I honestly believe that that's true. So check it out. I will put this link directly if you were looking to join it in the email afterwards as well.
Thank you, Stu.
And that's my pitch. So
Very good.
Scott, Murray, I learned a ton today. I appreciate you guys so much, and I've gotten multiple comments privately just for you guys that everyone thanked me for this, and so guys, I
good.
hope that you take advantage of this. This is the best price that I've ever seen to do all of this. So I really think that this is an amazing deal. So again, thank you guys.
Appreciate it. All right,
Yeah,
guys.
Okay,
enjoyed it.
have an amazing day.
All right. You too.
See ya.